Test, testing, test. Testing, test. Test.
Good morning. Good morning, everybody. Welcome back. If you will find a spot, we will get going. Good morning, everybody. Thank you to those of you who have returned for a third day. You obviously have tremendous endurance and a high pain tolerance. Appreciate you all being here. I don't think we have more than, I don't know, maybe 30 minutes of the line by line go through the rules part. Again, we would certainly welcome sort of a more open discussion dialogue. I don't know what I can maybe do to encourage that or foster that, but we'll make that opportunity available. Also, I want to say to the folks from Wadley Farms who have commuted down here each of the last 3 days, I would be more than happy to sit and visit with you all separately after the big group breaks up here. So I won't say I'll take as much time as you want, but I'll certainly make myself available for a good long chat if you would like. All right, so where we are in our process is looking now just at what we call conforming changes. Every time we tinker with rules, it has a ripple effect on some of the other rules. So everything really that we've looked at for the last 2 days have been new rules to implement recommendations 17 and 20. Now we need to spend a little time just going through some of the other changes to existing rules. In some cases, they really are just, we changed a subsection, so we need a different reference. In other cases, there are parts of our rules that, give us a certain amount of time to process a Form 2A, and we decided that we might need more time in certain cases. So I need the mouse. Thank you very much. Folks on the telephone, thank you for joining us again. And just a brief reminder, please, if you would, put your phones on mute so we don't hear the background noise, and please don't put us on hold. And if you're having if you're having trouble breaking in, text. Yeah. That if you're having trouble getting our attention, the best thing to do is text Kathleen Stacks.
720. You don't write this down. 346-5586.
What were the last four? Available 24/7.
Oh, man.
It's on the interweb now.
I know.
What?
Bring it on, people. Bring it on.
New phone tomorrow.
Yeah.
All right, here we go. This will be fun. So these are changes to existing rules. We have requirements that operators make certain certifications when they are applying for a Form 2A to us. Now, because we have something new called a large UMA facility, we need to accommodate that in this process. So there's a new part of the new subpart of this rule that says for a large UMA facility, the operator shall certify on the Form 2A that it complied with Rule 306B4, which is the pre-application notice to the local governments, or that the local government waived those procedures. So all those things we talked about, I think primarily on day one, 90 days pre-application notice, and then you have to either, get the waiver, get the agreement, the local government doesn't respond, or you go through the process. That's what the operator needs to certify on the Form 2A. So we'll be making some changes to that Form 2A for the operators in the room, and then we'll look for your certification that you have complied with that rule. The next change is to a rule that isn't used very often, to be perfectly honest, but there is something in our rules that allows operators to enter into something called a comprehensive drilling plan. That is a rule that has not been much used. Were it to be used, there would be some priority and preference given to a Form 2A that was governed by that comprehensive drilling plan. Here, we again simply change this rule to accommodate that concept for a large facility in an urban mitigation area. Under the EXISO background, for those of you that aren't familiar with this, in our rules currently, if the staff does not process a Form 2 or 2A within 75 days, the operator may elect to go directly to the commission for a hearing to get a decision on their Form 2A or Form 2. So that's a 75-day clock. Under the comprehensive drilling plan rule that's on the screen, that 75-day clock gets shrunk down to 30 days. The concept being that the comprehensive drilling plan sort of indicates that there's buy-in by the local government and everybody else as to that location. So we have to apply that same concept to the urban mitigation area facilities. We are proposing that we get 60 days rather than 30 days, just as we've proposed to extend the time. That 75-day time, we have proposed extending that to 150 days for the Form 2A for a large urban mitigation area facility. So it's proportional, but we are proposing that we would extend those times. This part is the rule that says what I just said verbally. An operator may request a hearing before the commission if the director does not issue a decision on a application for permit to drill. A normal application for permit to drill, 75 days. Sorry. And here we go. And application for a permit in a large UMA facility within 150 days.
Hello, this is Tori Jarvis. I don't know if this is the appropriate time to ask a question about that.
Go ahead, Tori. Why aren't you here today in person?
I have to go back to the West Slope.
Fair enough.
So I just hoped that you could give a little more information about how you envision evaluating consistency with the local government comprehensive plan, as that's really a planning document and not necessarily regulatory or any sort of binding document for a local government.
Yeah. So, Tori, I have to ask you some clarifying questions because I don't fully understand. I'm wondering if when I said comprehensive drilling plan, did you think I was referring to a local government comprehensive plan?
Well, if I'm following correctly, if we're looking at the C1, it says, consistent with a comprehensive drilling plan or a local government comprehensive plan. That specifies location. Am I looking at something different?
Just the key language there is that specifies locations for oil and gas facilities. So in other words, if it's covered under the comprehensive plan, then
Okay.
you're going to put oil and gas facilities here.
All right. Okay. Thanks. So Tori, here's, I think, where what we're getting at in that sentence that you're referring to is if that comprehensive plan specified locations for oil and gas facilities. So you've basically entered into an agreement with an operator or a surface developer that lays out where the oil and gas facilities will be. Then in that circumstance, we would try to expedite our review.
Okay, thank you.
Does that clarify? So it's not any comprehensive plan. It's a comprehensive plan that specifically contemplated houses go here, oil and gas facilities go here.
Yeah, that does make sense.
Okay,
Thank you.
you bet. Is this, somebody, I need help. Is this just the 30-day pre-application notice doesn't apply? Is that what this is?
Yes.
Yes? Yes. Okay. Next little subpart up on the screen, if the local government and operator have reached agreement regarding the site for a proposed large UMA facility, the notice requirement of this subpart does not apply. In our rules today, there is a pre-application notice requirement to local governments if you're building in an urban mitigation area, regardless of the size. So it's a 30-day pre-application notice. This just says if you've gone through this other process, you have a large UMA facility and you've gone through this other process, there's no need to give them now 30-day notice. They're on notice already. Okay. Our rules currently allow public comment and in certain cases comments by or consultation with the Department of Public Health and Environment or the Department of Wildlife. It was necessary to modify this rule because those comment periods, we've proposed changes to the comment period for large UMA facilities from 20 days to 40 days. So we just needed to make a conforming change to this rule. Instead of saying 20 days in all cases, we've said as long as the comment period is still active, the director will not approve a Form 2A. This is the part of the rule that we propose extending the public comment period for a large facility, large UMA facility, from 20 days, which is the default. In other cases, that default can be extended. Here, for the large UMA facilities, we're proposing that it from the get-go is 40-day comment period, but there are no proposed extensions to that 40 days. In our existing rules, there are circumstances identified in the rule under which the Colorado Department of Public Health and Environment either must consult with us about a proposed location or at which the local government can ask that the Department of Public Health and Environment consult with us. We have proposed for large urban mitigation area facilities that the CDPHE consultation is mandatory in all cases. Okay, we're done. All right. Seriously, that's all that we have listed to cover today. So are there questions about any of those things. Comments? Let's get Ms. Jost a microphone.
More of just a comment / question, but with respect to the extension of the 75 days to 150 days, was there, I guess, credence given to the act that provides for efficient and timely approval of those permits with respect to the 150 days? Because that could be quite the long time, depending on where you are, especially if you have an agreement and a local government agreement. Anyway, the 150 days.
Okay,
It seems like a very long time. Was credence given to the efficiency in the act?
First, I'll say that maybe 150 days isn't the number,
Mm-hmm.
but we know from experience that we're not getting these challenging sites
Mm-hmm.
reviewed in 75 days. So we would like a little more time just to be realistic.
Meaning internal COGCC
Yeah,
review?
yeah.
Okay.
Yeah, it's totally internal review. I mean,
Right.
from that's the intent here
Mhm.
anyway. If you have an agreement with the local government, from our point of view, again, that's going to streamline the entire process, because it's what's taking, well, you guys can tell me if I'm out of line here, but what's taking the most time is the alternative location analysis. So if that's off the table, we probably, the 75-day thing is not that big of an issue.
Great. Thank you.
BMPs, Greg is telling me that the BMPs take time. So again, some of that would be mitigated by the agreement with the local government. If the local government and the operator are on the same page about mitigation measures, that makes our jobs easier. Okay. Anything else? Ms. Sanchez. Publicly or?
Kim Sanchez, Boulder County. I'm just wondering if you could explain a little bit of the reasoning behind why an extension isn't allowable for this timeline versus the non-large facility UMA.
An extension on the public comment?
Correct.
Right. So the question for folks on the phone was why we haven't contemplated allowing a request for an extension of the 40-day comment period for the large urban mitigation area facilities. I guess really the short answer is the 40 days is the longest that we currently allow under any circumstances, whether you start at 20 days for an urban mitigation area facility that can be extended by the local government up to 40. In non-urban mitigation areas, it can be extended by the local government up to 30. So I guess our thinking was that starting out with 40 should be enough time and not really need an extension. Mr. Neslin.
Director Laporte, question about it's the conforming change to Rule 305A1, which in which you provide that the notice requirement, the pre-application notice requirement, wouldn't apply if the local government and operator have reached agreement. Yeah. Why would that not apply more broadly to simply to all large UMA facilities? Because you're going to require this kind of notice for all large UMA facilities at the outset. So the local government will have received the notice specified in this rule as part of your new notice and consultation process.
So if they don't respond at all. I don't know. We're on the verge of being stumped, but we're rallying. We have to go through all the scenarios in our brains. This is for those of you in the audience. This is what we do. Like for weeks leading up to this is do all these scenarios. So I think your question is well taken, but I think we tried to contemplate. So what if the local government doesn't respond at all to that 120 or that 90-day notice? We can't be sure that they got that. I don't know. I mean, you may be right, but I think in our minds, no response at all from the local government. That 60 days goes by. You're now at the 30-day mark. And we're saying, okay, you got no response from the local government. Give them a pre-application notice like you always did before and give us your Form 2A. We'll think about it. Maybe belts and suspenders in that case.
Think about it. The purpose, the rule says the purpose is as an invitation to engage in discussions regarding these issues. So, I mean, the notice looks really identical to the notice that you're requiring all large UMA facilities to provide.
Right. Appreciate that. We'll take a hard look. Get my attorney ready, please. Mr. Kramer has a question.
Just as Dan Kramer, City of Longmont, just as a follow-up to Mr. Neslin's question, maybe the answer is if the local government thinks an agreement might be possible, maybe if we're not sure if we're reaching an agreement, it would be nice to have direct communication. Hey, we're filing a Form 2A. That might not be immediately obvious to the local government otherwise.
Thank you. Yeah, that bordered on dialogue among stakeholders, so that was good.
Excellent.
Do you think that's it? That's woohoo! High point. You get credit for starting it. All right, any other questions or comments? All right, is there anything that we've covered in the last 2 days that anybody would like to comment on, ask a question about, pound the table, pull their hair? Yes, sir.
My question is, in case a site have an accident, a fire or lightning, and causing damage, etc., and does the oil and the gas company require to have a liability insurance or something, so they have the resource to pay whatever the damage they caused?
Yeah, the short answer is yes, and I'll tell you a little bit of the details. But again, I'm going to sit down with you all after we get everybody else out of here, if you want, and we can talk about these kinds of things more. But our rules require operators to carry a general liability insurance of $1 million. In addition, the COGCC has a fund that has $1 million in it at all times for response to emergencies. And then at the end of the day, just like any other entity, there's whatever legal recourse and litigation and liability for their negligence or what have you.
And but you were saying only $1 million?
That's what I said, yes.
Okay. And okay. Yeah, like I'm talking about some kind of damage, the big explosion causing a lot of property damage, people died. So do you think $1 million will be enough to pay those disasters?
I can certainly contemplate a scenario where $1 million was not enough to cover the damage caused, but that's just the amount of their insurance. That's not the amount of whatever other assets they have available that might be called upon if there was, through whatever avenue, a decision that they needed to pay more than that. Okay, let's hold that for the next discussion. Mr. Galloway.
Kevin Galloway. On 306B4, the notification on the large UMA facilities, it notes that the consultation is supposed to happen before an operator has a final contract with the surface owner for the specific location. I know we're trying to avoid hypotheticals, but oftentimes it's the surface owner and developer who initiates the SUA process, and we may already have an operations area set aside for the oil and gas company. So just wondered if we're contemplating the fact that what if the SUA is already in existence for that location and we don't have pending 2As?
So I think that what should happen in that circumstance is that if you haven't already involved the local government, you should do so post haste and explain that situation to them. I'd be very interested to hear the local government's response to this, quite frankly. In some of the outreach meetings, or maybe they were in meetings that weren't part of the public tour, what I think I heard local government say is that they would view those agreements as relevant information and not dispositive. And that, that's stuff that I don't really know very much about. But what I think you're positing to me is a scenario where a developer has sat down with the surface owner and said, here's where we want to build houses, and here's the places we'll set aside for the oil and gas locations. And again, if you ink that contract and you haven't talked to the local government, good luck with that. I mean, I don't know what to tell you in that circumstance. That's out of our league, really.
Okay, I just think we need to contemplate the fact that there may be an SUA in place, and it may even be in a plat at that point in time where we've set aside the AGOA that's been approved by the locals.
Then I think that's a much easier scenario. I think you're awfully close, I would think, at that point to having an agreement with the local government. And if they want to change that at that point, again, I think that's a conversation you're going to have with them, but you probably have some legal recourse opportunities there. Okay. Yeah.
Morning, Kelly Arnold, Town of Windsor. So I'm really Johnny come lately, and I'm here for another meeting with CML. I thought I'd drop in.
You didn't have to tell us that. Mr.
Okay,
Arnold.
but
thanks for stopping in.
Now that I'm here, I do have and I'm sure this is explained on day one, so I apologize if it was. Can you explain the queue? So that's the question I think we're raising, is the rules become effective when situational wise right now, if things are in the queue or not. So if they have an application pending, these rules are not relevant at this point, or are they? And if they have, can you just kind of go through that really fast?
I can.
For myself, maybe?
Yes, I can. So for folks on the phone, I apologize. I'm gonna repeat all the questions from now on because people on the phone can't hear them very well. So the question is with a timing question of the application of these proposed rules. And the short answer is that we intend to apply the mitigation measure portions of the new rules to applications that are pending but not approved at the time the rules take effect. We will not apply any of the consultation or notification requirements for pending applications. Those requirements will apply only to applications that are submitted after the effective date of the rule. Does that clarify?
So if they get in now, they're considered pending.
Yes.
But they are still subject to all setback notifications and consultations because they would be.
So they would of course be subject to existing rules, and existing rules include setbacks and notifications and such and so. Mr. Johnson.
Dan Johnston. To support your approach of dialogue among the stakeholders, I'd like to reiterate that early notification to adjacent surface owners would be advantageous. It would get citizen involvement happening early rather than later, where citizen involvement might be more likely to ball up the process. So again, I would like to support the director in that approach.
Thank you. I'm going to repeat your comment and then ask you a follow-up question. So for the phone, that's Dan Johnston. Mr. Johnston is a resident of Windsor who was very active in the conversations around the proposed PACE location that was originally in Weld County until Windsor annexed it.
Larimer County.
I'm sorry, Larimer County. Ooh, I apologize. Sorry. Only human. As has been pointed out to me a couple of times in the last few days. So the question is, it wasn't really a question. It was a reiteration of a request that at the time, I think this is correct, Dan, at the time that an operator would give notification to the local government of a large UMA proposed location, the operator would also give notice to adjacent homeowners or some set of homeowners' residences around the proposed location. Is that fair?
That's correct.
And so my follow-up question is, what do you think the right distance is? How far around that proposed location would you recommend that operators provide notice?
I would recommend no less than 1,500 feet. Desirable distance would be probably half a mile.
And why would you place that burden on the operator as opposed to the local government? And I'll just say that if it's on the local government, then the local government can notify surrounding property owners, homeowners, et cetera, for sort of whatever distance they want.
I believe the response to that is you probably don't have authority to require the local government to do that. And some local governments will happily do that, some will reluctantly do that, and some won't do that.
Okay. So maybe I could translate that into we should set a floor and local governments can go beyond that floor if they want to.
I think that's an appropriate approach.
For the record, Mr. Arnold agrees.
I have a follow-up question on a different topic.
Go right ahead.
Based on questions and responses over the last couple of days, I had a takeaway that the commission, the staff, might be considering defining a large-scale operation and not limiting the definition, at least, to a UMA area. Is that a correct takeaway, or is that an incorrect takeaway?
So I used, again, I'm going to repeat it for the phone. The question is staff contemplating changing the definition so that we define just a large facility and not a large urban mitigation area facility? So that, to me, my response is that proposal was made. I don't think staff has made a decision or taken a position. I'm happy to explain to you why I made the decision to define it the way that we have defined it.
Please.
Part of it was, as I said the other day, simply the way the rules read and writing the rules and referring back to a definition and so forth. It seemed much simpler to me to do it the way we've done it. The other part of it is the recommendation, and all of this consultation really is directed to large urban mitigation area facilities. We're creating a subset of best management practices that apply to those. In my mind, the cleaner, clearer way is to have something that's called a large urban mitigation area facility. But we note that there's an ask out there that we just define a large facility.
Do you believe that defining large scale generally would preclude you from applying best management practices only to large scale within a UMA?
not by the letter of that rule.
Thank you.
You guys are on detention. This is what happens when you have 3 days of these in a row. All right. Any last chance? I'm gonna come back to you, sir, when I sit down with the Wadley Farms people, unless this is very specific to the rules. Is this very specific to the rules? Okay. We'll talk about it. I'll talk about it with you separately. All right, we'll give you a microphone. Hold on.
Your mission say with the protection of public health, safety, and the welfare. That's one of your missions. Say
Yes.
say that, right?
Yes.
So I'd like to know that do you have any rules or anything related to protection of public health, safety, and the welfare?
Roughly
I don't know
somewhere
much
between
about
a
the
half and 3/4 of the rules in our rule book relate in some way to protection of public health, safety, and welfare.
Thank you.
Mr. Sura.
Thank you, Matt Sura with Boulder County. To bring it home to these rules, have your engineers done any analysis as to kind of a blast radius or area of impact for a 4,000 barrel storage of oil on site? The reason I ask is because there have been some really troubling explosions over recent years, and fortunately none of them have happened in neighborhoods. But if we're going to start drilling more in neighborhoods, as what it seems that this proposal might be gearing up for, it would seem that would be part of the analysis as to what mitigation measures need to be in place.
So the question for those on the phone is, have our engineers done an analysis of blast areas? I think it was the terminology of storage capacity on site. You know, Matt, I'm not going to be able to pull out a spreadsheet of any calculations that have been done, but I will point out that to the best of my knowledge, the fires and explosions that I think you're alluding to have had zero impact on anybody off of the location on which they're built. So to me, that suggests that the existing setbacks have proven effective through a wide range of incidents.
Well, in having looked at those incidents, there weren't any homes within 1,500 feet of those locations. So I don't know that you can say that it might have just been fortunate so far that we haven't had an explosion in a residential area.
Right. Right. Yeah. Right. Thank you. Oh, where's Kirby's? I'm sorry. Okay, we have a question or comment from Kirby Wynn in Garfield County. Mr. Wynn says, it is standard practice for area landowner notifications to be the responsibility of applicants rather than the local government. Each government has their own radius distance requirements. So whatever radius COGCC lands on, it should be operator responsibility to send notices. So Kirby, I hope you can hear me. I guess I need to ask some clarifications. I know for a fact that there are local governments who require notices in a larger area than we require under our current rules. So are you saying that that should be how it remains? That if a local government wants a bigger notice area, that's the local government's decision? Well, I'm kind of unclear what you're getting at. Maybe we'll get an answer in like 5 minutes. All right, we'll give Kirby some time here. So one thing I want to say, kind of following up on Matt Sura's questions and some of the other questions over here, it is our obligation to write rules based on science and factual evidence in every possible situation that we can. I've said previously that these rules feel a little different to us because it does feel like we're in some ways being asked to regulate behavior, which is sort of a different set of science. But when questions are raised about explosions and what have you, please bring us the evidence that there's some indication of a greater need for a greater setback or whatever it is. Kirby says yes. Good. 12. Okay. Answer is yes. Stay as it is. Yeah. Okay. Got it. Okay. Before I call on you, I want you to know that I've invited all of the Wadley Farms people to stay after and have a conversation with me. So yes. Yes, of course. All right. I think everybody just bought themselves a couple hours of extra time this morning. Thank you all very much again for your participation over the last 3 days. I really appreciate it. And I will stay and visit with you all from Wadley Farms.